Welcome back. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law, Windshield Time. Today I'm going to talk to you about discovery. I'm on my way to fight a discovery argument. And the reason I'm fighting a discovery argument is because it wasn't answered properly and in a timely fashion. Here's the trick. If you are in a court case and the opposing party sends you a discovery request, you have to respond to that. Even if that means your answer is simply, I don't know, or I don't object, you've got to answer. Or you have to request time to collect your answers. But objections need to be made within the time allotted. In Missouri, where I'm licensed, that's 30 days. I send and serve discovery on you. 30 days from then, your discovery is due. Now, we have some anachronistic time rules regarding weekends and non-business days when answers are due that don't really fit the modern legal environment, but the court hasn't removed those as of yet. So filing your response is something you have to do. 30 days is the rule. Generally, there could be a plus a day or two for calendar issues. However, 30 days. You send your interrogatories and your request for production to the other side. Then your interrogatories, you ask all kinds of questions. Typically, you ask questions that they're not going to have to answer if they file an objection. You do that because you hope they don't file the objection and they answer the question. It would be an impermissible question if they handled it properly. Generally, in every set of interrogatories, there's going to be several, half dozen, or a dozen or more improper questions that would have to be responded to in the appropriate manner. And that's fine. It's part of the game, and really that's what this is. It's a great big chess game. So, what happens if you're the receiving end of the interrogatories? Well, you have a limited period of time, 30 days, to write your answers, sign it, and return it. Now, if you've practiced law for any period of time, you've seen all kinds of ways to try and get around that, where they don't sign their answers. And usually if the answers are typed up and they're not signed, probably the attorney was trying to make the deadline and they couldn't get their client in to sign it. So then when you object to that and you bring it up, they say, oh, I'm sorry, that must have been an oversight. And they produce a copy that the client has signed. Had that happen, attorneys on the other side a couple times. I've never done it. I don't like it. I don't approve of it. So, objections to interrogatories, the objections that you do can range from the request is too broad, the request places an undue burden upon my client, it may cost my client money to produce all these records, which is really more relevant in a business case. However, it can be in a family law as well. Then you have the other objections that the item sought is equally available to both parties, that it's not relevant legally or logically. So there are a number of interrogatory objections that you can make. And frankly, if you're trying to do it yourself and you're not a lawyer, you can go Google and look it up, or you probably ought to talk to a lawyer, because it's very easy to get yourself into a jam. Now, that's interrogatories. Requests for productions, you got to produce documents that are already in existence. Now, a lot of attorneys like to submit forms and ask you to sign them or fill them out. that's actually objectionable. You don't have to do that. It's improper to ask you to create documents that are not currently in existence. Some of them are documents that the court's going to require in the progress of the case, so you don't really care, you're going to do it anyway. Sometimes you just want to object because you can. Some things like tax records for a married couple, they both have equal opportunity to go to the IRS and get that. That's something that if you have immediately available, great. If you don't, you object, because it's equally available to the other side. Now, in a request for production, I mean, you want everything. You ask for Facebook, you ask for other records. You know, this is where you're saying, hey, give it all to me. And let the other side object. If they don't object, let them produce it. The other part of the discovery process that a lot of people overlook, hell, a lot of lawyers don't use and don't use effectively, are requests for admissions. Now, in your request for admissions, you're basically making a statement and you're asking the other side to admit it or deny it. They have 30 days in Missouri. It's a hard answer. They've got to respond with admit or deny within 30 days, or everything they don't deny is deemed admitted. Now, if you deny it and I prove that it's true, I can get extra attorney's fees. Okay? We can get you to pay for that. So don't arbitrarily deny something, but make sure you read the question through like a lawyer and have a justifiable reason for denial. You know, if the question in interrogatories is, are you a meth dealer and you sell crack, not meth, your answer is going to be a denial. If it's, are you a drug dealer and you sell plastic baggies filled with meth, your answer could be a denial. I'm going to make you eat that in court, but at least it's arguable. And you're never going to admit to a criminal offense anyway. So if you have requests for admissions like that, talk to a lawyer, please. Don't try to do that yourself. But discovery is incredibly important. If you don't respond to your discovery within the 30 days in Missouri, then the attorney for the other side will file a motion to compel and request for sanctions. And those sanctions can be anything from you're paying the attorney's fees for the hearing on the motion to compel to striking your pleadings and entering a default judgment against you. So it's very, very serious. And failure to answer questions, I mean, I've won cases solely because the other side played games in their discovery responses. So don't do it. Play it straight. Yeah. So that's discovery. Very, very important. If you are in a case, you need to know it, you need to pay attention to it, and you need to follow your deadlines. If you are sending out discovery, you need to know it, you need to pay attention to it, and you need to track your deadlines. Your lawyer needs to be following up. If discovery hasn't been answered, we send a golden letter. I'll send a letter out to the opposing counsel that says, hey, you haven't responded to my discovery. If I don't hear from you within the next, if I don't get my response within the next 7, 10, 14 days, I'm going to file a motion to compel. And then I produce that communication as part of my evidence in the motion to compel. Judges hate discovery issues. As a rule, I have yet to meet a judge that enjoys a fight over discovery. So that's something to also bear in mind. If you want a good way to poison a judge and poison your case, get into a lot of stupid discovery fights in front of him that you're in the wrong. that won't go well. If you have to turn it over, man, turn it over. Don't play that game. So that's it. That's discovery. Answer your interrogatories in a timely fashion. Answer your requests for production. File the objections that you're going to need in a timely fashion. And if you can't make the deadline, you have to request an extension. One thing that a lot of people do, a lot of lawyers do, that I disagree with, is they will file an extension, but they never notice the hearing for the extension up. So the court never rules on the extension. If the court hasn't ruled on the extension, you don't have one. Don't ever miss a deadline in your request for admissions. That's all I got. Thank you for watching. Please hit like, subscribe, hit the alert button so you know when we have something else coming up. And I'll be talking to you later. Thank you.